India Legal presents Court This Week. Hello and welcome to Courts This Week. I'm Dina Osha. In this special edition of Courts This Week, we bring to you top stories of legal proceedings from courts, from lower and subordinate courts to high courts and Supreme Court. We bring a selection of major legal proceedings which made headlines this week. In the next half an hour, we will inform and update you on all important proceedings from the week. So let's start today's Courts This Week. India Legal presents Court This Week. The Supreme Court has been told by Solicitor General Tushar Mehta that the decision regarding the removal of 48,000 jugis near railway tracks in the capital would be taken only after consultations between the Delhi government and the centre. Mehta further assured the court that no evictions of the dwellers or demolitions of the jugis would take place till the time a meeting is held between Delhi government and the Union Ministry of Housing and Urban Affairs. The court was hearing a plea by Congress leader Ajay Makant and has slum dwellers who sought and intervened in the MC Mehta case, in which the Supreme Court recently ordered the removal of 48,000 jugis shanties along the 40 kilometers of railway tracks around Delhi within 3 months. The matter was heard by a bench of Chief Justice of India S.A. Bobde and Justice A.S. Bopanna and V. Ramasubramaniam. The intervener had approached the court seeking that the residents of 48,000 jugis said to be around 2 lakh people are relocated before being evicted. Senior advocate Abhishek Manu Sangvi informed the bench that though S.G. Mehta submitted that there would be no demolitions, demolition did take place on Friday and Monday. However, Mehta stated that such demolitions were done pursuant to some other matter and not the one being heard. The case will now be heard after 4 weeks. On August 31, a bench headed by Justice Arun Mishra had ordered the removal of the jugis due to the issues of environmental degradations, accumulations of plastic waste, among others. The centre opposed a plea filed before the Delhi High Court seeking to recognize the rights of the same-sex couples to get married under the Hindu Marriage Act 1956. Representing the Union of India, Solicitor General Tushar Mehta submitted that the concept of same-sex marriage is not recognized under the Indian culture or under Indian law. Our culture and law doesn't recognize the concept of same-sex marriages, Mehta said. As per law, a marriage is only between a husband and a wife, argued Mehta to urge that Hindu Marriage Act, the act itself, did not recognize same-sex marriages. The bench comprising Chief Justice D.N. Patel and Justice Pratik Jalan, however, expressed that such petitions must be viewed with an open mind. Acknowledging that though the positions of the law might be different, the bench stated that changes are happening across the world. Mehta, however, maintained that the effect of the Supreme Court's 2018 judgment in the Navtej Singh Johar's case was only to decriminalize consensual homosexual activities. Nothing more, nothing less. The court went on to suggest that the petitioners who were activists are members of the LGBTQ community and would first try and get their marriage registered, and if in case they were denied, they could approach the court with their grievance. Appearing on behalf of the petitioners, Advocate Raghav Avasthe informed court that there have been instances of gay couples getting married but being refused registration. The court thus asked the petitioners to bring on record all those persons who are aggrieved by the non-registration of the same-sex marriages on the next date of hearing and posted the matter to be considered again on October 21. The court was hearing a PIL which sought a declaration recognizing the rights of the same-sex couples to get married under Hindu Marriage Act 1956. The Supreme Court has granted former Punjab Director General of Police Sumeet Singh Saini interim protections from the arrest in relation to the Balwant Singh Multani murder case. The three-judge bench of Justices Ashok Bhushan, S. Subhash Reddy and M.R. Shah also issued notice returnable by 3 weeks in anticipatory bail plea filed by the Saini, who is an accused in 1991 murder case. Senior counsel Mukul Rohadgi, appearing for Saini, submitted that his client was decorated officer who rose through the ranks during the heights of militancy in Punjab. Rohadgi claimed that the Punjab government was after Saini because he had filed 2 charge sheets in which current Chief Minister of Punjab, Captain Amarinder Singh, was named. Senior advocate Siddharth Luthra, opposing the bail plea, contended that Rohadgi was attributing motives to the judge that rejected Saini's bail plea. He went on to state that the High Court had noted that Saini's misused his powers. After hearing senior advocate K.V. Vishwanathan appearing for the Multani's brother, the court proceeded to direct that no arrest can take place before the state government's reply is heard. It thus issued notice in the matter directing that rejoinders be filed within a week. Sainis have challenged the Punjab and Haryana High Court's September 7 order dismissing his anticipatory bail plea in the Multani kidnapping and murder case. The apex court is also receipt of a caveat from the Punjab police to preempt Sainis from getting any ex parte relief. Multani, a junior engineer with the Chandigarh Industrial and Tourism Corporation, was allegedly picked up by the police in December 1991 after a terror attack on Saini that killed 3 policemen. Saini was injured in the attack. Former Punjab DGP Sumeet Saini is accused in kidnapping and murder case of Balwant Singh Multani's son. The special CBI court at Lucknow will deliver on September 30 the verdict in the criminal case related to the conspiracy behind the demolitions of the Babri Masjid Mosque in 1992. Prominent BJP leaders L.K. Advani, Kalyan Singh, Uma Bharti, Murli Manohar Joshi, among others, are accused in the case. All 3 are 32 accused. The special judge Surendra Kumar Yadav have asked the accused person to be present in the court on September 30 for the pronouncement of the judgment. The Supreme Court has extended a deadline for the trial court to complete the trial several times, with the last extension given on August 19, 2020. On April 19, 2017, the Supreme Court bench of Justices P.C. Ghosh and R.F. Narimand has restored the conspiracy charges against the accused by allowing an appeal filed by CBI against the discharge given by the Allahabad High Court to them. Invoking its extraordinary constitutional powers under Article 142 of the Constitutions, and the bench also transferred the pending separate trial in the Bareilly Magistrate Court and clubbed it with the criminal proceedings in Lucknow CBI Court. The top court has further ordered day-to-day trial to be concluded in 2 years in the case. The Supreme Court has rejected the central government's petition challenging the enforcement of a Malaysian arbitral award passed in favor of the Vedanta in relations to the Rawa oil and gas fields. The Supreme Court held that the enforcement of this award will not go against the public policy of India. The order dismisses a petition filed by the Union Ministry of Petroleum and Natural Gas against Vedanta over the enforcement of 2011 arbitral award. The court was considering the applicability of the Malaysian laws in Vedanta's foreign award when the contract provided for Indian laws to govern the transactions. Last month, the Supreme Court bench of Justices S. Abdul Nazir, Indu Malhotra and Aniruddha Bose has appointed senior advocate Gaurav Banerjee to assist the court on the issue. The centre had moved the Supreme Court challenging the decision of the Delhi High Court which allowed Vedanta, formerly known as the Cranes India, to implement the foreign award of 2011, which allowed the company to seek a larger sum of recovery instead of the amount that was capped by the Indian government. The dispute pertained to the productions of the sharing contract between the Cranes India and the Indian government with respect to the explorations of the Rawa oil field in the Krishna Godavari basin. This contract was a period between 2000 and 2007. The court was informed that despite this negative covenant provided for the contract, the objections to the contract have been decided by the Malaysian court in line with the Malaysian public policy. Now, at the enforcement stage, the Indian courts are required to examine whether the award goes against Indian public policy. The Supreme Court made some strong observations while restricting news channels Sudarshan TV from telecasting the remaining 5 episodes of its show Bol Bindas that talks about Muslims who get through the UPSC exam until further orders. Also, in a petition before the top court, the centre made it clear that since the petition is confined only to one channel, Sudarshan TV, the Supreme Court may not undertake the exercise of laying down any further guidelines with or without appointment of an amicus or a committee of a person as the amicus. The centre made it clear in the petition that it is the digital media which the Supreme Court should look at first and then TV or electronic media, as the latter is governed by the cases and precedents. The Supreme Court has restrained the Sudarshan TV News from telecasting the remaining episodes of the Bindas Bol, a show about a Muslim clearing the UPSC exam until further orders, after prima facie observing that the object of the show was to vilify Muslims. A bench of Justices D.Y. Chandrachud, Indu Malhotra and K.M. Joseph was hearing a petition filed against the telecast of the show hosted by the channel's chief editor, Suresh Chavhanke, on the ground that it was communalizing the entry of the Muslim into UPSC. At this stage, prima facie, it appears to the court that the object, intent and purpose of the program is to vilify the Muslim community with an insidious attempt to portray them as a part of the conspiracy to infiltrate the civil services, the court observed in the order. The top court noted in the order that there were factual incorrect statements made in the program regarding the upper age limit and the number of attempts for Muslim in UPSC exams. The edifice of a stable democratic society under a regime of constitutional rights and value is founded on the coexistence of communities. India is melting pot of civilization, culture and values. Any attempts to vilify a community must be viewed with greater disfavor by this court, which is a custodian of the constitutional rights, the court observed. Senior advocate Shyam Diwan, appearing for the channel, and Chavhanke staunchly opposed to stay on the telecast by arguing that a prior restraint order will violate free speech. Claiming that the show was a part of the investigative journalism, Diwan denied that there was any vilifications of the Muslim community and asserted that the show was about a journalist unearthing details about the foreign funding from the sources that are not necessarily friendly with India. During the hearing, Justice Chandrachud said, "This is not a freedom of speech issue. When you say students of Jamia are a part of the conspiracy to infiltrate civil services, that is not permissible. You cannot target one community and brand them a particular manner. This is an insidious attempt to malign a community," the judge said. "As the Supreme Court of the nation, we cannot allow you to say that Muslims are infiltrating civil services. You cannot say that journalists has absolute freedom doing this," the judge said. The bench reflected upon the ramifications of how electronic media can be used as a tool to threaten national security and stability and pondered upon the need for putting forth regulations. Justice Chandrachud also made observations regarding the importance of having some regulating standards for television news channels, as reach of the TV is more than newspapers. Talking about journalistic freedom, Justice Joseph also observed that journalistic freedom is not absolute. A journalist shares the same freedom as any other citizens, and there is no separate freedom for journalists like in the United States. Therefore, journalists who are fair in their debates are needed. Senior advocate Shyam Diwan opposed the court's suggestions of deferring the program's broadcast till the next hearing and stated that there cannot be a pre-broadcast ban. The nature of the show is that of an investigative story and considers the issue at one hand as one of the national security and is in public interest, and there is also no enormous amounts of funding from abroad. Bureau Report. The Supreme Court has directed the Chief Justice of all High Courts to prepare an action plan in order to expeditiously deal with pending cases against members of Parliament and members of the Legislative Assembly. The bench of Justices N.V. Ramana, Surya Kant and Rishikesh Roy had now issued the following directions. The Chief Justice of each High Court should formulate and submit an action plan for rationalizations of the number of special courts necessary, bearing in mind the number of pending cases in each district, the number of special courts needed proportionally, the number of courts currently available, the number of judges and their tenure, expected time for case disposal, the proximity of courts and adequacy of the infrastructure. In the event that the trials are already ongoing, the Chief Justice may also consider whether it is appropriate or necessary that the cases should be transferred to a different court. The Chief Justice should designate a special bench comprising themselves, their designate in the order to monitor the progress of the trials. The Chief Justices are requested to give their comments on the other suggestions of the amicus curiae for the purpose of appendice disposal of pending criminal cases against legislators. Additional suggestions, if any, may also be sent to the Supreme Court. The action plan with the comments and suggestions of the Chief Justices of the High Courts is to be sent to the General Secretary of the Supreme Court, preferably within a week. A copy must also be sent to the amicus curiae by the way of email. Matters could be conveniently heard through video conferencing while passing the order. The bench also remarked that special consideration is being given by the court to this issue in view of the rising wave of criminalization that was occurring in the politics in the country. And given the power that elected representatives sitting in or former willed to influence or hamper effective prosecution. During the hearing on the cases pertaining to the Delhi riots, a senior advocate, Colin Gonsalves, informed the Delhi High Court that delay causes in the taking up this case's matter for arguments is emboldening the policy to police to make illegal arrest. The submission was made before the division bench of Chief Justice D.N. Patel and Justice Pratik Jaland in a matter concerning a bunch of petitions seeking independent inquiry and registrations of the FIRs for communal violence that took place in the Northeast District of Delhi. The court has been adjourning this matter for the reason that it wants to complete the hearing on Jamia violence matter first. Due to this repeated adjournments, Gonsalves argued that the court must take up this matters regardless of the progress made in the other matters. Due to the illegal arrests that have been taking place, we want to seek transfer of investigation to an independent agency both in this matter and the matter pertaining to the Jamia violence, he argued. Echoing the concern for urgent hearing, Advocate Tara Narula also argued that since the final charge sheet in the Delhi riots cases have been filed and the trial will commence shortly, it is pertinent to commence argument in this writ petitions as expeditiously as possible. After taking this concern on the record, the court reiterated that it will hear this matter after completing the hearing on Jamia matters. The court then adjourned the matters pertaining to Delhi riots till October 1. A Delhi High Court has granted bail to Pinjra Tot member Natasha Narwal, who is accused of instigating the riots that took place in the Northeast District of Delhi. While granting bail, Additional Session Judge Amitabh Rava noted that the video shown by the prosecution does not show Narwal participating in the unlawful assembly. But it doesn't show anything to suggest that she indulged in or incited violence. The court further observed that Narwal doesn't pose any flight risk and all the witnesses in the case are either police officers or protected witnesses. Opposing Narwal's bail, Delhi police argued that she had opened up her office near the protest site where meetings were held to further their steps to organize protests and riots. These meetings were also attended by Umar Khalid, Mahmood Pracha and Amanatullah Khan, as well as Delhi police argued. The police also argued that by showing that she is a PhD scholar from JNU and that she knows the law, she instigated people to get violent and throw stones to defend themselves from getting evicted. The court also noted that the co-accused, Devangana Kalita, was granted bail by Delhi High Court on September 1. Despite being released on bail in the present matter, Narwal won't be released from the prison as there is another FIR registered against her under Unlawful Activities Prevention Act. Narwal is currently lodged in Tihar prison as an accused under the 3 FIRs that have been registered against her for allegedly fueling the riots. A special court at Jodhpur has asked the CBI to file cases against the former Union Minister Arun Shaurya and the then Disinvestment Secretary Pradeep Baijal over the sale of an ITDC hotel, allegedly at a loss of rupees 244 crore to the exchequer. The CBI court has also directed the filing of cases against 3 others associated with the sale of 2 decades back of Lakshmi Vilas Palace Hotel in Udaipur during the term of the Atal Bihari Vajpayee-led National Democratic Alliance government at the centre. Shaurya was the minister in charge of the divestment when the property owned by the public sector India Tourism Development Corporation was sold to Bharat Hotels Limited, a private company. The court recalled Shaurya's background as a journalist who had spoken against corruption in debate and interviews. This proved his double standards on the issue of corruption, Special Judge Puran Kumar Sharma said. In Wednesday orders, Sharma rejected the closure report submitted in the case by the Central Bureau of Investigation in August 2019 and asked the agency to re-investigate it. Meanwhile, the Allahabad High Court has launched a website specially keeping in mind the middle class. The website named Allahabad High Court Middle Income Group Legal Aid Society. This will allow the middle income category to get cheap and accessible justice easily. The High Court has launched the society under the scheme of Supreme Court. So far, the Legal Services Authority had provided free advice and help to give cheap and accessible justice to the people of lower income group. Through this special scheme, special arrangements are made for the middle class within the annual income of Rs 6 lakh and Rs 12 lakh. The litigant may fight their case if needed or on a very nominal fee. The work of this middle income group legal aid society will be able to provide legal aid to needy and the counseling, legal treatment and represent them in court if required. Apart from this, there will be also benefits in cases of arbitrations and settlement centers and arbitration. The speciality of this service is that the legal assistance will be made available to the needy at home through email, video call or social media platform. Well, that's all in courts this week. Thank you so much for tuning in. Keep watching APN and stay safe. India Legal presents Court This Week.